The problem that this overreach of authority leads to is many constitutional violations, which creates a huge liability and which is beginning to create excess litigation in the courts because this has gotten out of control and people are fed up with it. Individuals are getting educated, lawyers are getting educated. Because of the overreach of authority is creating due process violations, privacy violations, equal protection violations, fundamental rights violations, and spending powers violations. It's huge. The problem here has a potential to cost a lot of money to the government because of that unwarranted, unauthorized overreach of authority. The second question is how can the state be assured the state won't lose the entire funding for 4A and 4D services as the DHS claims and as they have stated in testimony? First of all, I want to share with you the CPR philosophy, again, based on our research. In order to protect the family, we're asking the legislators to ensure that the state law and agency policy are acting within the scope of congressional intent. We're asking that the legislators ensure the state law and agency policy are acting to ensure the constitutional protections to all parents. And we're asking the Minnesota legislators to be innovative leaders and to be on the leading edge of this inevitable change, which we believe is going to have a domino effect across the United States, because everybody is looking to be fiscally responsible. By reducing the number of applicants and recipients of 4D, by taking out the non-needy recipients, we're reducing the unnecessary government expense and increasing public aid money available to either reduce the budget as a whole or to take that money, personnel, and move it to other programs for people that are truly needy, where the programs might be in jeopardy right now. This is consistent with even what Al Gore has said, that to achieve the goal of government is to do better with less. So we're asking two things: that the Minnesota legislature consider modifying the state law to clarify eligibility standards for 4D welfare services, and to clarify the limitations of government intervention in private cases. Here's the testimony back to April of 2003. In red, there were 3 threats given to the legislator by the DHS. Those 3 threats in red were, 1, the DHS is telling the Minnesota legislator, we have to provide these services. Number 2, they're saying, if we don't provide these services, we're going to violate the state plan. And number 3, if we violate the state plan, we're going to lose $350 million. Whereas as legislators, that's hard to hear. I would be concerned if I was you too, if you thought you were going to lose $350 million. But we've done the research to find out if this is true. Where is the specific reference in the state plan? We can't find it. The DHS also says the feds make us do it. Well, based on the research, do you think that's true? One of the federal codes that the DHS will bring up to to object to our theories is 42 U.S.C. 654-482, which the 3 magic words on the end of this are the ones that are causing the most problem. In federal law, it says that they must provide the services to everybody on welfare, and then number 2 at the bottom, any other child, if an individual applies for such services with respect to the child. Okay, you look at that, and again, depending on the lessons you've gone through on statutory construction, that may or may not be clear to you. What we say is that we have looked at many controlling authorities on this statute, on this law. We've looked at the rules of statutory construction. Our research team has looked at the poured through the Federal Register, poured through case law, poured through congressional intent again, to say, any other child, what does that mean? What we found is that the word other has specific meaning in the law. That if the federal government would have intended, they made 2 distinct classes. If they would have wanted to include everyone, they would have said any child, not any other child, or they would have said all children, not any other child. This also is about a 20-minute conversation, which I won't get into now, but I want you to know we've done the research and we remain confident, maybe even doubly confident, that our interpretation is right, that nothing has ever changed in the congressional record to expand the class beyond those at welfare and those at risk of being on welfare. The Minnesota DHS will also bring up one of the regulations, 45 CFR 302.33. In there, that regulation says the state plan must provide that the services established under this plan are made available to any individual. So the Minnesota DHS comes and says, see, we have to provide those services to everybody. Again, we've done the research. And based on our research, the only way that you could believe that to be true is if you believe that providing services is the same thing as making services available. I use the Walgreens example. You know, Walgreens corporate tells all their stores, you have to make aspirin available in all your stores. It doesn't mean you have to provide aspirin to every person that walks through the door, if they haven't met the criteria that's needed for aspirin. We've also looked in the Federal Register, as I mentioned before, and there's a specific quote in the Federal Register where they attempted to make some changes in Congress with any other within Title IV of the medical provisions. And the Federal Register makes it very clear that the word other has very special meaning. The Minnesota DHS will also bring up 45303.2, which, by the way, all these statutes we knew about and we had researched before they brought these up. Because we're always trying to be one step ahead. We're always trying to check and double check all of our research to make sure that we are right so that we aren't purporting anything that ends up becoming wrong in the future. Well, in 303.2, they claim that they have to make these services available to everybody based on this. But what we find interesting in this particular regulation is it said that they must open a case based on an assessment. Well, guess what? Remember what I said earlier? There's no assessment process taking place at all with these applications. Plus, there is a difference between the word accept and approve. Of course, they have to provide an application to everyone or there would be discrimination issues. Of course, they have to accept a filled out application from everyone who fills one out or they would be accused of discrimination. But to approve an application is quite another thing. And as we've seen on the congressional record, you would approve an application if somebody qualified.